Welcome to UO Today. I'm Paul Pepis, Director of the Oregon Humanities Center. My guests today are Maxine Burkett and Elizabeth Kronk Warner. Maxine Burkett teaches climate change law and policy, torts, ocean and coastal law, and international environmental law at the William S. Richardson School of Law at the University of Hawaii. Elizabeth Kronk Warner teaches federal Indian law, Native American natural resources law, and property law at the University of Kansas School of Law. Burkett and Kronk Warner were keynote speakers at the U of O's 2016 Climate Change and Indigenous Peoples Symposium, addressing tribal sovereignty, traditional knowledges, and climate-induced change among indigenous peoples in the United States. Thank you so much both for coming on the show. Maxine, let me start with you. You focus on climate justice as it relates to vulnerable island communities in particular. What are the challenges that islanders are facing right now?
Right now, yeah, that's a great question. It's varied. Right now, the challenges that islanders are facing in the Pacific are really around fresh water, actually. The near-term challenges are a little bit different from the longer-term challenges around sea level rise, which is a big concern, especially for low atoll nations. Obviously, there's not much high ground, and there's some concern about being able to continue to live in the islands that they've lived in for generations. But at this very moment, it's water. And it's lacking.
So what's the kind of quantity of human beings that are going to be impacted by these changes? Do we have any idea how many people we're talking about?
Well, in terms of total number, if you're looking just at Pacific Islanders, we're not talking about we're talking about a few million, which is still very important, obviously. These are challenges that are going to be faced by a number of communities worldwide, so you're looking at much larger numbers. In the Pacific, though, the islands that are atoll nations that are looking at potential total uninhabitability of their islands, Kiribati has a population of about 100,000, 10,000 in Tuvalu. We're talking about much smaller numbers, but still there are challenges in terms of coordination of potential migration over time.
Now, you just talked about potential migration, but climate migration,
yes,
or some people call them climate refugees, that's already happening.
Yeah, I mean, and I'll just sort of make a finer point with respect to the term. I mean, climate refugee is very sort of evocative and really helpful for us to understand the phenomenon. But as far as sort of legal terminology, there's a very specific definition of what it means to be a refugee, and that's lacking, many would argue, from the circumstances of most people that are moving as a result of climate change. But what's happening now is definitely a series of relocations and displacements that are about climate threats, that things that have been amplified by climate change. Again, you can imagine that if you are in an atoll in the Carteret Islands, for example, in Papua New Guinea, and your atoll has been carved in half, you can't grow taro, you don't have access to fresh water. These are reasons why communities have been moving in the Pacific, but it's also happening in the United States. We see that there's relocations that are happening that are being planned, if not fully executed, in Alaska. We see this also in Louisiana as examples of current domestic relocation as a result of climate change.
So in places like these islands, Papua New Guinea, for example, or other Pacific islands, it's conceivable that, as you say, that some of these islands will go away.
Yeah.
So entire populations will be displaced. So what happens to those nations when the land that is where they are is no longer there? What happens to them?
Well, that's the subject of a lot of research and conversation and some controversy at this point. I mean, this isn't these are discrete kinds of issues that I think will be relevant to other communities, but the notion of actually having territory that actually may still be there, but doesn't produce fresh water, doesn't have a freshwater lens, for example, or has no longer has arable land. I mean, these are circumstances that we haven't seen before. We usually understand a state and an international legal personality as having a territory. This is the sort of the new frontier that we're at from a legal perspective as to how to answer that question. There's been some creative answers.
So one of those creative answers is from you.
Yeah.
and your concept is nations ex situ. So what does that mean? What is that about?
There's some discussion about the possibility of having a state, again, one with international legal personality, a placard essentially at the UN General Assembly. that is deterritorialized, one that does not have territory but still has the ability to represent its nationals in important diplomatic affairs, to be able to provide representation for those communities as they are moved to different points of the globe, which are oftentimes still unsettled. And it would allow for there potentially to be a continuation of identity and culture, though virtual. And I use that I use sort of myself as an example. I'm a part of the Jamaican diaspora. Obviously, having the island still in existence makes a very big difference in terms of my identity. But the notion that I'm Jamaican and an American citizen and having that longstanding connection, even outside of place, physical space, is one that might be able to have a new sort of manifestation in this sort of post-climate world.
And there's some old legal precedents, right? The Brotherhoods of Malta, right?
Yes, yes, that's right. They have gotten much more attention recently. But yeah, there are notions of legal entities that can serve as international entities for political or economic reasons, the EU being one that's sort of this amorphous entity, Taiwan being sort of a contested space, but also the Tibetan identity and the fact that they still hold elections even though the government is in exile. There are a number of ways that we see historical analogs serving as just that, an analogous situation that doesn't match the specifics of this exactly, but allow for a more sort of expansive and creative approach to our very unusual and unprecedented phenomenon of deterritorialization as a result of sea level rise and other climate events.
Are you optimistic that these new legal categories can be established? Do you think this will happen?
I don't know. And I will say that largely because there's an element of climate change that's completely impossible to predict. And so what I do know is that we do need laws that can be more nimble to respond to the unknowns. And so how can we allow for that that kind of new kind of culture within the law to respond to the surprises that climate change will necessarily introduce?
So one more question for you.
Yeah.
You served as the inaugural director of the Center for Island Climate Adaptation and Policy. Tell us about that center and the work that you did there.
Yeah, so what we were hoping to do at ICAP for short, it was quite a wordy title, but one that was very descriptive. What we were trying to do is really bridge the information that was happening within disciplines, so the sciences. We worked with law, regional planning, with Hawaiian studies. We were looking at how to get these important disciplines to work together to come up with real world solutions that were not just based on sort of our research and publishing in journals, but using that work in an interdisciplinary fashion to then translate that from the university to communities that needed assistance and decision makers to support them to make better decisions. And so the center was always looking for opportunities to create those learning vehicles and actually hoping for that to manifest in policy and better community planning.
Has it manifested in policy?
Well, we've done some important work and worked with island communities outside of Hawaii as well, but certainly I would say we have, and the publications that we produced at the time still have a very long tail in terms of relevance, right? When we were talking about how to have better policy with regard to sea level rise at all different scales, these are changes that were imagined over time. There were short term, near term, medium term, long term, and we're seeing some of those solution sets being sort of investigated now for some better policy in the state of Hawaii in particular.
Okay.
Yeah.
So Elizabeth, your work focuses on intersections between environmental law and Indian law. Why is that conjunction important?
So I come primarily from a tribal background, so I'm a tribal citizen, was raised on a reservation, and what's so important for a lot of our indigenous communities, and I don't want to make a pan-Indian statement, it's certainly not true for every Indian or every tribe, but for a lot of us, place is very important for our ceremonies, for our rejuvenation, and also culture is intimately connected for many of us to the environment. So having access to, for example, in my tribe, sacred berries is very important for our subsistence and for our culture and traditions. So there is this nexus between culture and traditions, again, for many of us, not for all of us, and the environment and location. So therefore, I see preservation of the environment as intimately connected to cultural sovereignty and traditional sovereignty, and seeing those two as interrelated.
So you contend that the concept in Indian law of sovereignty is a crucial tool to make these environmental justice arguments. In particular, you focus on the Arctic region. Now, this is a region where displacement because of environmental change is also happening, but you're also interested in, so on the one hand, you're interested in legal tools for mitigation of climate change, but you're also interested in adaptation. Why is adaptation so crucial in your view here?
Because as Maxine mentioned, a lot of our indigenous communities in the United States are already being displaced. So Alaska, South Carolina, Louisiana, we already have people who've been displaced and removed from their land. So it's not a question of when anymore in the United States, it's already happening. So that's why, yes, mitigation is still important. If we can decrease the impacts, that would be great. But the reality is that it's already happening. So we need to, in our local communities, look at solutions that we have and opportunities that we have to really reduce those impacts. And that's something when I talk around the country, I like to talk about the fact that our indigenous people here in the United States are really experts at resiliency and adaptation. We've had to adapt to so many horrific things throughout our history, whether it's natural phenomenon or human-based phenomenon. And so I really see a lot of our tribal communities as being leaders in adaptation and resiliency. And so I hope to kind of take that message abroad.
Are you finding that the United States government and the culture at large is beginning to get the message that tribal communities have this particular expertise and particular knowledge to try to deal with these problems? Are you finding that, is progress being made on that front?
Yes, I would say, actually with the Obama administration, we were talking about this last night, I think there are a lot of people in the Obama administration who get it. And the Obama administration, at least from the Indian side of things, now the environmental conversation might look a little bit different, but on the Indian side of things has been very progressive in the way that they've approached tribes, and they've accomplished a lot. And one of the things that they did accomplish through the Bureau of Indian Affairs is getting some appropriations from the federal government to help with this displacement. Now, it was a drop in the bucket. Some of these relocations are estimated to cost $200 million per community. So we certainly haven't seen federal expenditures along those lines. But we are seeing some recognition of the federal government's responsibility in that capacity. The other way that I see some kind of positive changes, and Kathy Lynn, who works here at the University of Oregon, has been really influential in this, is changing a recognition from the federal government that sometimes I think we still have that paternalistic model of, oh, it's the great father who's going to help us in this situation, but also encouraging the federal government to recognize that tribes are doing some really innovative things that the federal government can learn from, because the federal government hasn't been that active in climate change and climate change mitigation and adaptation. So really kind of encouraging the federal government to be reflective on what tribes are doing, and maybe there's some things that the federal government can take away from where tribes have been working. And I know Kathy Lynn's been working on some national guidelines to really assist the federal government maybe in reorientating itself and how it views tribes, not as the lesser to take care of, but rather to maybe potentially learn from tribes.
I know that you say that tribes are laboratories for this kind of innovation. Can you give us a particular example of this kind of innovation that's coming on the table?
So Justice Brandeis talked about how states are so important to the federalism because we get to be laboratories, individual states, right? And ideally you learn from what states do really well. And I think the federal government and states can learn from tribes. And so a great example of that, I think, is in the water context, which Maxine was talking about. So tribes have, under their inherent tribal sovereignty, have developed water quality criteria standards, which recognize not just anthropological uses of water, but also cultural and spiritual and natural uses of water, and a much more holistic vision of water, I would argue, than what you see, for example, in the Clean Water Act. And so I think that's a good example of where the federal government could really learn from tribes and having a more holistic view of water.
Tell us about your work on the Inuit Circumpolar Council.
Yeah, so the Council, or the ICC for short, brought a petition to the Inter-American Human Rights Commission in 2005, and it was really kind of a watershed moment of bringing a couple of movements together, bringing the climate justice movement together, Indigenous rights movement together, and then also human rights together in a really important way to show that the emissions of then the United States at the time was the largest emitter of greenhouse gases. We've since been surpassed by the People's Republic of China, although we still are the largest per capita emitter. but brought a complaint against the United States saying that because of the United States emissions, it was a violation on the Inuits' human rights because aspects of their culture were being infringed upon because of the changing environment. And then also there was property loss because of the changing environment. Like Kivalina, for example, the native village of Kivalina in Alaska is literally falling into the sea because of the impacts of climate change. And so really arguing that they were losing and are losing essential human rights, right? The right to shelter, the right to food, the right to property were being lost because of the impacts of climate change. Now, ultimately, they were unsuccessful, and I use that term loosely from a legal perspective because the commission ultimately determined that a nexus between the United States' greenhouse gas emissions and the impacts in the Arctic, it was too difficult to show that direct relationship. However, you could also argue that it was really a win because the commission said we're going to remain seized of this issue, we're going to continue to investigate it. We've subsequently seen several Indigenous rights complaints that have been brought to the commission along these same rights, and we saw kind of the discussion around these issues just balloon from the complaint, and I think people are really aware of the issues now. So, I mean, technically, from a legal perspective, it wasn't a win, but I think we've seen a lot of positive movement moving forward.
So that helps me raise the next question that I'd like to ask you both. So you're both professors of law. You're both approaching the problems of climate change through the lens of the law, and you both obviously believe that the law is a critical tool in this project. So what are the benefits that the law can bring to address the changes that climate change is bringing about? What's good about the law for this?
That's a great question. I've often walked into a room of climate scientists and they're like, law, lawyer, what are you doing here? But I think this is an incredibly critical space, and I'll say there are a number of positive things that the law can do to advance our efforts to mitigate, adapt, and manage the sort of inevitable losses that will result from climate change. And we saw the Paris Agreement as one example of an important foothold, perhaps a couple decades later than we would have liked it, but an important foothold for future more aggressive action on climate change mitigation and adaptation. But we also know that not dealing with the law, not engaging the law, can also have very negative impacts, which is something that was introduced by Professor David Caron back in 1990. Right, so 26 years ago, he wrote an article about legal feedback mechanisms, the notion that poor legal plannings, laws that are not responsive to climate change can actually entrench or aggravate the experiences of climate change and negative experiences of it. So you can imagine a number of circumstances from small to large. One circumstance would be if we have hunting permits for communities in Alaska, for example, that are not shifted based on what we're seeing in terms of seasonal changes. This has a very significant impact on communities that are using subsistence hunting as a core part of their experience, all the way up to the issue of migration and the climate refugee, which is the fact that as we cross borders, they themselves become these legal realities that are quite challenging to manage without important changes to the law.
Yeah, and I don't see them as legal solutions being mutually exclusive. I see them as being in partner with other disciplines. But legal solutions have been really effective for a variety of communities. So, for example, the ICC petition that you brought up earlier really shed a light on this intersection of environmental, climate justice, and human rights and how those things merge. The native village of Kivalina brought a complaint and brought a lot of focus on the impact here domestically. I think until they brought their complaint, we tended to think about the impacts of climate change as, oh, that's happening someplace else, and really brought that message home. Then you have tribes that are doing tribal adaptation under their inherent sovereign legal authority and doing some really great things locally to tribes that are looking to find expression through their treaties. So I see the law as a tool to be used in conjunction with other disciplines to really work with a community to let them say, well, what's your ultimate goal? What do you want to accomplish? Law is one tool that can help you in that direction. And the other nice thing that I see in a lot of these complaints is it's an opportunity for the community to really tell its own story. So, which is so important for communities to have space to give these narratives and to share with the world what's really happening for them. And a legal complaint can be a very obvious way of sharing that story in a way that'll get national attention, which maybe if you don't bring a complaint, you might not shed a light on it. So I think that they can be really important narrative tools as well.
I'm also interested in the fact that we're in a moment when environmental lawyers are trying different strategies. So I know that one of them is the nuisance argument, that it's a public nuisance, and then there's these public trusts arguments. Have environmental lawyers sort of realized what the best strategies are, or is it very locally determined which tactic, which strategy is the best strategy, legal strategy to use?
You know, with something like climate change, there are so many ways that we lawyers and the law are implicated. So we actually have to be, again, very sort of creative and think very expansively about the various tools we might use. And so all of those would be really critical elements of getting to changing the law. I know you worked explicitly on our Children's Trust work, so that might be sort of more one of the important avenues.
Yeah, and I would just say, you mentioned environmental lawyers. I think it's all lawyers. It's important to look at this, not just from an environmental lens, which might be restrictive, because environmental lawyers tend to look just at statutes, versus I think the people who are doing the work here in Eugene, the Our Children's Trust, would maybe say they're constitutional or public trust lawyers, and looking at it from a different lens, and that really drives home the point that as of right now, we're not going to find a end-all be-all one-shot solution. And so it's really important for different communities to look at their domestic options, their international options, and to see what works. And Our Children's Trust here in Eugene is a great example of that. So they're taking a concept, the public trust doctrine, which was very popular in the 1960s, 1970s, and for a variety of historical reasons kind of went away a little bit. Not that it's no longer a viable legal option, but just was not as popular in the 80s, 90s, and early 2000s, and are really retooling that and saying, look, we have this duty to protect our public resources, and our atmosphere and the water that you were talking about is our important natural resources, and so we need to protect it. And so they're being very creative, very progressive, and thinking about how to take this this concept that was popular in another age and reapply it to this modern challenge. And I think that's exactly, we need lawyers like that, and advocates, not just lawyers, but kind of thinking, for lack of a term, outside of the box of how to apply things in new and creative ways.
So for me, I just keep thinking of David and Goliath in this case, right? Because these kids, and it's just a bunch of kids, are going up against the oil and gas industry and the government. I mean, I totally understand why the government and the oil and gas industry has to fight this battle, but why would they want to fight against a bunch of children? It just seems insane, but that's what they're going to do. Are you optimistic about that case?
Well, actually, I think the fact that they have children and that they went this direction was brilliant on their part, because it does make it a better narrative, right? Because I mean, the law is narrative, is storytelling on some level, and to have these, they've done such a great job of picking children from all around the United States who have such heartbreaking, but yet from kind of a legal perspective, great stories to tell. And I think it makes, the fact that it is children makes it more capable of success, perhaps. So I think from that perspective, they've been very smart in the way that they've framed their narrative. But yeah, I mean, obviously they've already had a huge win with the magistrate decision here in Oregon, so that's fantastic. They've been having great success on a state-by-state level, and in some states that you might not think would be persuaded by these types of arguments. So I think on kind of a local state-by-state perspective, this is an argument, the public trust argument is one that definitely has legs and definitely is going to be successful. I think the harder nugget is the federal United States-wide litigation, and the district of the circuit court for the DC Circuit has already said that they did not find that argument persuasive. So on a national scale, I don't know if this is going to be the argument that's going to win the day. But on some level, that doesn't matter, right? Because the impacts of climate change are very localized. So if they continue to have this success on a regional and state level, which I think they will, that could accomplish a lot of the goals of communities and what they want to do. So I think it's really exciting what they've accomplished and what they're doing.
It's a thousand cuts problem too, right? You have to think about this in a way of sort of, there are 1,000 Davids. And in fact, you know, these kinds of actions will be buttressed by investigations by states of Exxon's activity and what the oil and gas companies have known over time, our understanding about the relative contributions since 1750 of 90 companies globally that are involved. And also, you know, when we think about climate change, we are thinking a lot about the politics of it in the United States, and the political cycles run in very short fuses. And in fact, this is an issue that, you know, sort of extends beyond any of us, and kids in particular demonstrate the fact that we're talking about actual living beings' futures, and these are things that are going to impact all of us. We're talking about a generation or two in some catastrophic ways, potentially.
So we have 3 minutes left. This is probably the last question. You were on the show 6 years ago, and it was right after the Copenhagen Climate Summit. And you were thinking about Mexico City. So here we are 6 years later. Last week, they signed the Paris Agreement. I mean, 160 countries signed it. Are you optimistic about this event? Is this a profound turning point? Or is this just a bunch of propaganda and government? You know, it has no teeth, it's all voluntary. What do you think?
Yeah, thank you for that. I mean, we have been on a journey. This is much longer than even the past 6 years, and I would say that the Paris Agreement has had a number of celebratory words and a number of communities, including small island states, that were very enthusiastic about the progress that was made, and I think they were right. I think that we didn't expect very much, and we got some of the things that we needed, and that was absolutely a cause for celebration. And then there are a number of people who said this is completely inconsistent with the science. It's not scientifically appropriate. It's not justice-oriented. It's not going to move nearly as fast as we need to, and they're right as well. So in some ways, the optimism question is you know, I'm always optimistic. I have children. I'm invested in the future. And I also know, though, that what this means is that it's basically an agenda. It's an agenda for how much work we have to do, and it was just the beginning of a much longer journey. So I think the Paris Agreement's success will be judged by all of the follow-on activity. If we can up the rigor, up the intensity, get all of the U.S. on board, and understand it as a defining issue, then yes, we will have done well, but we can't know the answer to that, I don't think, for some time.
You get the last word.
Yeah, so what she said, it's a very, there's a lot of controversy about whether it's a good thing or a bad thing. I think at the end of the day, I'm optimistic like Maxine. It's good that our international leaders are focused on the issue and aware of the issue, so I see that as a positive. But I think for the reasons that she stated, why people are perhaps disappointed with the agreement is more encouragement for those of us working at the local level that we need to continue on the local level, and we're probably not going to get the end-all be-all answer at the international level that we want, so it's really kind of a call for those of us to continue our local efforts.
Thank you for sharing that call with us. Good luck to you both in pursuing that call. It's been great talking to you. Thanks for coming on the show.
Thank you.
I've been speaking with Maxine Burkett, Professor of Law at the University of Hawaii, and Elizabeth Kronk Warner, Professor of Law at the University of Kansas. They were keynote speakers at the U of O's 2016 Climate Change and Indigenous People Symposium, addressing tribal sovereignty, traditional knowledges, and climate-induced change among indigenous peoples in the United States. Thank you both. Thank you. Thanks for watching.